Andrew, you've been watching the U.S. Supreme Court for some time, and a lot of interesting cases are popping up. One that I think's got a lot of people's attention was about nonviolent drug users and whether or not they have a Second Amendment right. And you're talking with legal experts that anticipate the Supreme Court may actually overturn that case. Tell us about it.
Yeah, exactly. Thanks for having me, Greg. This was a shocking case, really. Every legal expert I've spoken to, and even myself, was shocked to hear about this. The case is U.S. versus Hamani. It's centers around a man in Texas who was found in possession of a firearm and also had marijuana and cocaine on him, according to court documents. When he was found with that, it was seen in clear violation of a law that restricts unlawful drug users from possessing firearms. So the Trump administration pursued him and sought to disarm him, and they filed a petition to the Supreme Court seeking to uphold this law that disarms felony drug users from possessing firearms. However, once we got to the oral arguments, which were just a few days ago, many of the justices appeared to side against the Trump administration. A lot of these justices were pointing to examples of other drugs and controlled substances that may be used unlawfully, something like Ambien, where somebody uses somebody else's prescription Ambien, a spouse uses their significant other's Ambien. And if they are in possession of a firearm, does that get taken from them at that point? So the justices really appeared very, very skeptical. And based on those arguments, they were honestly, some legal experts I've spoken to anticipate a reverse ruling from what was initially expected. Again, the Trump administration sought relief in this case, and it was expected that the justices would side with them, but it's not looking like that's going to be the case. And some experts have said it could be an 8-1 opinion against the Trump administration.
It'll be interesting to see what the ramifications of that will be, as it is unlawful by federal law to be a habitual user of illegal drugs and marijuana, even though recent actions from the Trump administration to try to reschedule that, it's still considered in that, Schedule 1 category, right up there with the likes of LSD and cocaine. So that's going to be a fascinating one, but that's not the only one impacting the Second Amendment. There was another case that the Supreme Court declined to hear about felony gun possession. Tell us briefly about that one.
Yeah, there's another case, exactly like you said. this is the third time the Supreme Court has rejected a felony gun possession case that's similar to this. This case was based from a woman who was disarmed because she committed bank fraud. She committed check fraud, and that is a nonviolent felony, but she was barred from possessing firearms because of that. And so that's the third case in recent months that the Supreme Court has rejected to hear along those similar lines. There were two others with similar bank fraud and wire fraud issues, more nonviolent crimes where individuals were disarmed. But the Supreme Court decided they're not going to hear that again, to hear that case in the Second Amendment. So it's a very fascinating development in there. The woman was a mother, and she has appealed to her status as a mother, as someone who works in social assistance, and she has been stripped of her right, but she has said that I'm innocent here. It was a issue years and years ago. It doesn't affect how I have my possession of firearms now. But the court has rejected to hear that, and will continue to keep this law against nonviolent felons.
Well, Andrew, this obviously is a lot to take in, but there's even more cases involving some very controversial issues. The Supreme Court's had a busy session this spring so far. They're looking at also a variety of different immigration style cases. Tell us what we're looking at there.
Yeah, we're looking at a lot of different immigration cases from the Supreme Court. We have one upcoming arguments. Arguments are set for March 24th in a case to determine at what point an immigrant arrives in the United States. This is going to be a very complex issue because federal statute requires that once an immigrant, quote, arrives in the United States, they are entitled to asylum protections, or at least entitled to an asylum hearing. However, the Trump administration is arguing that that arrives is very different than what some other advocate organizations are hoping to seek. Some organizations are saying that once you cross that U.S.-Mexico border, that is a determinant of arriving in the United States. But the administration has recently tried to push back on that and allowed less people to come across that border, which is brought in this big legal issue of how do you define the term of arriving in the United States? Is it when somebody crosses that threshold at the border, or is it at a different point? So that'll be heard on March 24th, and that'll be really interesting. And then additionally, they've already decided a significant case about the conditions, forced labor conditions at immigration detention camps, and across the country. And they've determined that a lot of these private contractors that own these prisons and facilities are no longer able to push out with forced labor conditions on those immigrants at these detention facilities.
And some of the other cases that are coming up, as you mentioned, you've got the asylum case on March 24th. It's right around the corner. You've got also a birthright citizenship case that's going to be heard April 1st. And also mail-in ballots, something that the Supreme Court's going to be taking up. And that's one thing that has been interesting to see how they've handled, for instance, a case out of Illinois, right? I mean, the case that Congressman Mike Bost brought forward, that was about, 2 weeks after Election Day, and can they actually, be in the jurisdiction and be somebody that's aggrieved and harmed by that 2 weeks? I mean, they didn't decide on that issue about the 2 weeks. They just had to decide on the jurisdiction issue, right? But that's something else that could be coming back, and they're dealing with another case dealing with mail-in ballots March 23rd. Tell us about that one.
Yes, that mail-in ballots case is going to be pretty significant. It's a challenge to the mail-in ballot receipt deadline, specifically the receipt in Mississippi. Mississippi currently allows mail-in ballots to be received up to 5 days after an election, as long as those ballots are postmarked by Election Day. This is really significant because it really gets to the heart of, like you were saying, Greg, the heart of the merits in that Bost decision, that the court already sided with Congressman Bost on that. But they're going to be challenging this provision in Mississippi, but this is going to affect states across the country. 14 states and the District of Columbia allow mail-in ballots to be received after Election Day, as long as they're postmarked by Election Day. As I'm sure you know, Greg, in Illinois, those ballots can be received up to 14 days after Election Day, as long as they're postmarked by that day. So the court is really going to come into this deciding what does it mean that in the federal statute, Election Day is set for a certain day? Does that mean that ballots can't be received after that point? And what does it look like, especially as we look at changes going on in the Postal Service and how things are being postmarked moving forward, what that means for mail-in ballots and counting ballots that are received after a federal election day. So it'll be really significant.
Andrew, obviously another big issue they've dealt with is the issue of transgender ideology and policies. We could probably spend 20 minutes just talking about that, but I do want to get your thoughts on what seems to be kind of an interesting case concerning Guam and hazardous disposal. What's this case all about?
Yeah, this case really came out of left field, I'll be honest, at least for me in my experience. So since about 1982, the Air Force has disposed of hazardous munitions and material on a private beach that's closed to the public beach in Guam. They've disposed of, dangerous material, hazardous material that they use in, war fighting and all of those things. And they've done that for, like I said, decades. Each time that they've had to do that, every few years they have to apply to a certain statute that allows them to show that the dumping of these materials is not going to harm the environment in Guam. But back a few years ago, back in 2021, an environmental group in Guam decided that the Air Force did not meet the proper qualifications to explain that this wasn't going to be hazardous to the environment. So they challenged that, and they specifically brought in a statute that requires an organization to put in a environmental impact statement, no matter in anything that they're doing, when they dispose of these hazardous materials, which is something that the Air Force hadn't done in the previous years when it applied. So the Air Force is really going to be looking at this really seemingly technical procedural challenge, but it's going to have some far-reaching implications for environmental standards and whether or not they can dump some of these hazardous materials in Guam like they've been doing since 1982, Greg.
Again, a lot of different issues that the U.S. Supreme Court's tackling, and Andrew Rice and our team over in Washington, D.C. and across the country keeping close tabs on all of that. So be sure to get the newsletter in your inbox at thecentersquare.com.